Hello and welcome to the Joinder essay approach. This is the last approach in civil procedure and I hope you enjoy it. When does joinder come up? Well, it comes up quite frequently on the California bar exam. And what we're looking for are facts that support someone that wants to or should be joined into a case. And the question becomes, how important is it to the case and the deciding of the case that that party actually is joined in? Let's take a look at your approach. A joinder is the act of joining several legal issues together in the same lawsuit. A joinder allows for two or more issues to be heard during one hearing or trial, so as to make the process run more smoothly and to help ensure the outcome is fair for all involved. Now, there's two main types of joinder that are tested on the exam. The first one is compulsory joinder, and it means what it really sounds like. It means that that party must come in. It must come in order to proceed with the case. So that is the first type of joinder. You're only going to go into the type that you have. So it's important to know the difference between when someone should come in or could come in as opposed to when someone must come in. Let's take a look at the rule. A party must be joined if complete relief cannot be given to current parties in the initial party's absence. A decision in his or her absence might impair his or her ability to protect his or her interests, or the absence would expose existing parties to a substantial risk of double or inconsistent obligations. So the next thing, that's a little brief intro you'll give, and the next thing you're going to do is to determine how necessary this party is to coming into the action. Some parties must be forced to join an action because their presence is required. If they cannot be joined and the court dismisses the action, that party will then be deemed to be indispensable. So your job is to determine how necessary that party is. So for instance, the driver of the car of the accident, if you're only suing the insurance company, it's probably going to be a necessary party that must come in, the actual driver of the car. So you'll determine how necessary it is based on the factors and give some good analysis there. The court is the one that determines that if the party cannot come in, the party is indispensable and therefore the action should be dismissed until that party will come in. So this is how you're going to set it up. Now, what about a permissive joinder situation? Turn the page. Oh, and also I've given you the number of factors to consider as to whether one is necessary. And it's right there going through number 1, 2, I'll read it just briefly. Factors for the court to consider include the extent to which a judgment rendered in the person's absence might prejudice the person or the existing parties, the extent to which any prejudice could be lessened or avoided by productive provisions in the judgment, shaping the relief or other measures, whether a judgment rendered in the person's absence would be adequate, and whether the plaintiff could have an adequate remedy if the action were dismissed for non-joinder. So those are factors the court should consider. You should know them, you should memorize a few of them and be able to discuss them for a compulsory joinder issue. Permissive joinder. A permissive joinder allows two or more parties to join an action if they each have a claim that arose from the same incident. Similarly, a permissive joinder is allowed if there is a common question of law, this is the key, common question of law or fact that pertains to all the parties' claims. Some examples of parties who may be joined are multiple plaintiffs suing a defendant over the same transaction or occurrences, multiple plaintiffs suing multiple defendants over the same transaction or occurrences, and raises at least one common question. Note that there must be both subject matter and personal jurisdiction when the person comes in. An example of joinder, that is a permissive joinder, would be several landowners coming together to sue a company for dumping toxic waste in close proximity to their homes. Each landowner could effectively file a claim for the same relief, including emotional distress and even actual damages. So now, don't give the example. After you give your brief permissive joinder intro, then analyze if the parties should be joined based on a common question of law or fact to the current parties. And that's it. So you're just determining why they should come in, okay? That is the key analysis. And again, it's based on the common question of law or fact. So make sure your analysis is pretty clear here. Joinder is definitely not a very lengthy section of your answer. Very rarely will you have an entire essay based on joinder or even an entire essay based on preclusion, by the way. Those are crossovers with usually within other areas of civil procedure. Now, civil procedure could cross over with a number of different areas, right? We could have civil procedure crossing over with almost any civil area like torts, contracts, real property, constitutional law, so on and so forth. So be on the lookout for any potential specific cause of question where you're getting out of maybe a cause of action and they're asking you some civil procedure question.